Okay, hello class. This is going to be your finals and it's jury charge. So let me give you, make sure you speed build beforehand. Whatever method you use for your speed building, make sure you speed build, okay? These are just your finals. And so you have on your 180 jury charge number 1, you have none, no proper names, okay? So this is going to be final 180 jury charge number 1 for 5 minutes. Members of the jury. In this case, as in all civil cases, the affirmative of an issue must now be proved. Proving that issue here is upon the plaintiff as to all of the affirmative claims of the complaint. The burden of proof then rests upon the plaintiff in this case. In a civil proceeding such as this, a preponderance of evidence is all that is required. By a preponderance of the evidence is meant such evidence as, when weighed with that opposed to it, has more convincing force. Now, you have all heard the testimony. You saw the witnesses as they gave their testimony. You had a chance to observe their manner on the witness stand, any show of nervousness or lack of it, any hesitation. Did any of them pause and hesitate while giving their answers, or did they speak out freely? The law says that you may even take into note the facial display of the witness as he gives his testimony in deciding what weight and belief you will give him. Consider all the events around the witness in the giving of his testimony. The speech of the witness and demeanor of the witness, all are to be considered and weighed by you in determining what probative weight and force you will give to his words. The facts in this case may be established by 2 varieties of evidence, that is, direct or by circumstantial evidence. The same facts may also be proved by the both of these 2 types of evidence. Now, circumstantial evidence may be referred to as indirect evidence too. It is that sort of evidence that tends to establish a fact by proving some other fact and which gives an inference or presumption of that fact. It is your obligation as judges of the facts in this case to consider and weigh all the testimony of all of the witnesses whom you have observed on the witness stand. You are the judges of the credibility of them and of the weight to be given to their testimony. It is your job as jurors to determine the truthfulness of a witness. You are the finders of the truth. If there are any conflicts in the testimony of different witnesses, you must, to the best of your ability, decide what is true and what is not true. You should give the testimony of each witness the weight that you believe it deserves. If you think, in fact, that a witness has sworn falsely to some vital fact in the case, you may ignore all or part of that person's testimony. Testifying falsely is the opposite of making an honest mistake or forgetting. To reach your verdict, you may address only the testimony and exhibits given in evidence. Some things are not evidence and you may not consider them in saying what the facts are. Statements by the attorneys are not evidence. The attorneys are not witnesses. Questions by lawyers are not evidence. Lawyers have a duty to their clients to object when they believe a question is improper under all of the rules of evidence. What you may have seen or heard when the court was not in session is not evidence. You are to decide the case solely on the evidence received at the trial. Contributory negligence is a want of due or reasonable care on the part of the person harmed by the negligence of another, directly adding to the harm and acting as a proximate cause thereof. Another meaning of contributory negligence is failure on the part of a person harmed by another's negligence to use ordinary or reasonable care to avoid the injury. Damages cannot be gotten for injury, the commission of which a person has directly added to. If the passenger in a car is at fault because of doing something which he or she shouldn't have done, or failing to accomplish something he should have done, then he cannot get damages for any injuries to himself or herself. Before you can find that the plaintiff is barred from recovery, though, you must find that his or her negligence played a substantial part along with the defendant's negligence in then causing the accident. If in using ordinary care under the circumstances, the plaintiff should have been aware of some danger which the defendant was ignorant of, or if the defendant was not using proper caution in the operation of the car, then the plaintiff cannot recover even though the driver was negligent. But if you find after reviewing and studying the evidence that as the car in which plaintiff was traveling reached the location of the accident, the plaintiff did use the care that an ordinarily prudent person would have used under the same events with regard to warning the driver, then the plaintiff was innocent of contributory negligence. In the case we are concerned with here, there is no legal presumption of negligence. Negligence is a fact which must be first proved by the plaintiff to allow him to recover. Thus, I instruct you that neither the mere happening of the accident involved or the filing of the complaint raises a presumption of negligence. Members of the jury, it is a very important role that you play in our system of jurisprudence because you are the judges of the facts in this case. There are in effect two judges. And then we have your second 180. And words that come out, you have sorry about that. Government, grand jury, and United States. Government, grand jury, and United States. This is your second 180 jury charge and capitalized court, okay? When you can replace judge in the sentence. For 5 minutes, you all, your final exam. Ladies and gentlemen of the jury, we have now reached that point in this particular case where it becomes your duty to determine whether the defendant in this case is guilty or not guilty of the offenses set out in the indictment. It is the duty of the court to instruct you on the law that applies in this particular case. That is, the rules and the principles of law that apply. It is your duty as jurors to follow the law as it shall be stated to you. That is, the rules and the principles of law that apply to this particular case. When the court tells you that it gives you the rules and the principles of law that apply to this particular case, the court does not imply nor are you to infer that you are not the sole and exclusive judges of all of the questions of fact. On the contrary, ladies and gentlemen of the jury, you are the sole judges of all questions of fact. It will be for you and you alone to determine all issues of fact from the evidence which has been submitted from the witness stand and from the reasonable inference that you may deduct from proven facts. Counsel for the government and counsel for the defendant have the right to make opening statements to you, indicating to you what they maintain that their respective parties will show through the evidence. They also have the right at the conclusion of the testimony to indicate to you in summary what they maintain that their respective parties have shown to you through the evidence. However, ladies and gentlemen of the jury, the statements of counsel in the opening statement or in the closing argument are not evidence, and any remarks they make are not to be considered by you as evidence. In this particular case, there have been objections made by respective counsel as to what other counsel was saying. The court wants to clearly indicate to you that this case is to be decided by you from the evidence which has been submitted from the witness stand and from the reasonable inferences that you deduct from proven facts in the case. If counsel in their closing argument should have stated any fact which is at variance with your recollection of the testimony which you have heard, then it is your recollection that controls and not that of counsel. The court quickly adds, ladies and gentlemen of the jury, that the court has the right to comment on testimony. The court ordinarily does not comment on any testimony, but if the court should comment in any way on the testimony which has been submitted to you, and if the court's recollection, then it is your recollection that controls. Now, ladies and gentlemen of the jury, at the outset, the court instructs you that the mere fact that the defendant in this case has been indicted by the grand jury for an offense is not to be considered by you as evidence of guilt. The sole function of the indictment is to advise a defendant of the charge which must be faced when the case comes on for trial before you. It is not evidence of guilt. It is a method also of bringing this defendant into court and presenting the case to you for your consideration and for your final verdict. You have heard, ladies and gentlemen of the jury, the question of reasonable doubt or proof beyond a reasonable doubt. The court instructs you that the burden of proof rests upon the government to establish the guilt of the defendant. This burden is known in the law as proof beyond a reasonable doubt. The government has the burden of establishing the guilt of the defendant beyond a reasonable doubt. The defendant is not required to establish his innocence under our system of jurisprudence. When I say our system, I mean throughout the entire United States. The law never imposes upon a defendant in a criminal case the burden or the duty of calling any witness or to produce any evidence at all in his defense if he should so elect. We then get to the question, ladies and gentlemen of the jury, of what is a reasonable doubt. Reasonable doubt, as the name implies, is a doubt based on reason. It is a doubt for which you as jurors can give a reason. It is such a doubt as would cause a juror, after a careful and impartial consideration of all of the evidence, to be so undecided that he or she could not say that they have an abiding conviction of the defendant's guilt. It is such a doubt as would cause a reasonable person to hesitate to act in the more important transactions of his or her own life. The government has the burden to establish guilt of a defendant beyond a reasonable doubt. The jury is instructed that you are the sole judges of all questions of fact. It is for you to say what weight you will give to the testimony of any witness who may have testified during the progress of this trial. In determining whether the government has established the charge against this defendant beyond a reasonable doubt, you must consider and weigh the and then we've got your 160s. 160 number 1, proper names. You have TV, capitalized TV, and that's it. This will be your 160 number 1 jury charge for 5 minutes, you all, final exam, okay? Ladies and gentlemen, you have now been sworn as the jury to try this case. By your verdict, you will decide the disputed issues of fact. I will decide all questions of law and procedure that arise during the trial. And before you retire to the jury room at the end of the trial to deliberate upon your verdict and decide the case, I will instruct you on, that is, I will explain to you the rules of law that you must follow and apply in making your decision. The evidence given to you during the trial will mostly be of the testimony of the witnesses and the items, including papers or documents, called exhibits. You should pay close heed to the testimony since it will be necessary for you to rely upon memories as to what the testimony was. Though, as you can see, the court reporter is making steno notes of all that is said. The transcripts will not be prepared in time for your use during your deliberations, and you should not expect to receive them. On the other hand, any exhibits put in evidence in the trial will be given to you for detailed study if you wish during your discussions. So, if an exhibit is given in evidence but is not fully read or displayed to you at the time, don't be concerned because you will get to review and study it later during your deliberations. If you would like to take notes during the trial, you may do so. On the other hand, of course, you are not required to make notations if you do not want to. That will be left up to you individually. If you decide to take notes, be careful not to get so involved in note-taking that you become distracted from the ongoing case. Also, your notes should be used only as aids to your memory, and if your memory should later differ from your notes, you should rely upon your memory and not your notes. And if you do not take notes, you should rely upon your own recollection or memory of what the testimony was. And you should not be swayed by notes of other jurors. Notes are not due any greater weight than the recollection or the impression of each juror concerning what the testimony was. A question sometimes arises as to whether certain members of the jury will be permitted to take notes during the trial. Now, the desire to take notes is perfectly natural for those of you who are accustomed to making notes because of your schooling or the nature of your work or the like. It is requested, however, that jurors not take notes during the trial. One of the reasons for having 6 persons on the jury is to gain the advantage of your several individual memories about the testimony presented before you. And while some of you might feel comfortable taking notes, other members of the jury may not have the skill or knowledge in note-taking and may not wish to do so. During the trial, you should keep an open mind and you should avoid reaching any hasty ideas or conclusions. Hold your judgment till you have heard all of the testimony and evidence, the closing arguments or summations of the lawyers, and my charge or explaining to you about the applicable law. Because of your duty to keep an open mind during the trial, coupled with your duty to then decide the case only on the basis of the testimony and evidence presented, you must not discuss the case during the trial in any manner among yourselves or with anyone else, nor should you permit anyone to discuss it in your presence, and you should avoid reading any news articles that might be written on the case. You should also not view or hear any TV or radio comments about the trial. Also, you must not visit the scene of the events involved in this case unless I later instruct you to do so. From time to time during the trial, I may be called upon to make rulings of law on objections or motions made by the lawyers. You should not infer or conclude from any ruling or other comment I may make that I have any opinions on the merits of the case favoring one side or the other. And if I should sustain an objection to a question that goes unanswered by a witness, you should not guess or speculate what the answer might have been, nor should you draw any inferences or conclusions from the question itself. Now, during the trial, I may have to confer with the lawyers from time to time out of your hearing with regard to questions of law or procedure. And then we have your second 160 jury charge. And you have proper names. None, okay? No proper names. Let me make sure. This is going to be your second jury charge final exam for 5 minutes, you all. Members of the jury, we currently approach the critical time in this case, the point where the case will be delivered to you for your decisions and verdict on the facts. It is my responsibility to enlighten you on the law. However, I first want to thank you for your patience, your attention, and your cooperation during this trial process. I will begin by explaining to you my role and your role. The jury's role is by far the most important. It is to determine the questions of fact and on the basis of those facts to reach the verdict. It is your duty to decide whether the plaintiff has proved her case by a preponderance of the evidence. You are the only judges of the facts. That is a huge responsibility that you are to carry out with total fairness and no prejudice. Your decision is to be based only on the evidence or the lack of evidence. It may not be influenced by bias, prejudice, or sympathy. I remind you that this is the duty you have sworn you would faithfully perform. My job includes 2 basic functions. First, I make rulings on disputed issues of law. What rulings I have made should not be of any concern to you. My second function is very much your concern. It is to give you instructions on the law. That is, I must explain to you the rules of law that govern your deliberations, and I must tell you the questions you must answer in reaching your verdict. It is your responsibility to accept the law as I state it to you in these instructions and to apply the law to the facts as you determine them. You must not substitute your interpretation of what the law should be for what I tell you the law is. Just as you alone determine the facts, I alone determine the law. And you are duty-bound to accept the law as I state it. Similarly, if any attorney has stated a legal principle differing from Any that I state to you in my instructions, it is my instructions you must follow. You should not single out any instruction as alone stating the law, but you should consider my instructions as a whole when you leave to deliberate in the jury room. To that end, you will all be permitted to take your copy of these along with you into the jury room. Second, statements of court and counsel are not in evidence. In deciding the facts, you must rely on your own recall of the evidence. And what is evidence? It consists mainly of the testimony of witnesses and exhibits that have been received in court. It also includes facts or testimony that have been stipulated or which I have instructed you should be taken as true. This case is not to be decided on the speeches of the lawyers. What the lawyers have said in their opening arguments and their summations, in their objections or in their questions is not evidence. What I say is not evidence. Only the answer of a witness is evidence, along with documents and other tangible things received in evidence during trial. One exception to this is that you may not consider in any way any answer that I disregarded and directed you or ordered you be stricken from the record. Forget it and pretend it was never said. Erase it from your mind. The statements and arguments made by the lawyers are intended to convince you what conclusions you should draw from the evidence or lack of it. Now, those arguments are important. You should weigh and evaluate them carefully, but you must not confuse them with the evidence. When deciding what the evidence was, it is your memory that rules, not the statements of the lawyers. You should draw no inference or conclusion for or against any party by reason of lawyers making objections or rulings on such objections. Counsel have not only the right, but the duty to make legal objections when they think that such objections are fitting. Also, during the course of the trial at different times, I sustained objections by one counsel to a question asked by the examining counsel. Where I sustained objections to counsel's question, you are to ignore the question and any alleged fact contained in the question, and you may not guess as to what the answer would have been. Additionally, do not draw any inference from any of my rulings. The rulings I have made during the trial are not any clue to my opinions of what your decision should be with respect to whether the plaintiffs or the defendants have given more convincing evidence. At times, I questioned a witness myself. Any? Okay, that concludes your jury charge, you all, and we'll continue with your list, okay?